All right. Welcome, everyone. I know a lot of people are going to take a couple minutes to trickle in, but we've got a packed agenda today. So we're just going to get started. We'll do a couple intros first, and then we'll get going. So I know many of you come to these webinars every month, but we do have some new people here today. HR Simple is the company that I work with, or that I work for. We create human resources manuals for employers. And to make that happen, we partner with a law firm or a couple law firms in each state. And we also partner with the state chamber. So today we have, our speakers are from Fredrikson, and they are one of the law firms we work with in Iowa. So we just thought it made a lot of sense to invite Michele from ABI, which is essentially the state chamber in Iowa, just to come and say a quick hello to those of you who are already members, and do a quick intro for those of you who are unfamiliar with ABI. So Michele, welcome today. Thanks so much for joining us.
Thank you, Amy. It's so great to be here, and thank you for including me. Just wanted to also thank Fredrikson, who is an advisory council member here at ABI, and HR Simple, who was part of our By ABI program. Real quick, since 1903, ABI is Iowa State Chamber. We represent over 350,000 employees in all sectors all across the state. One thing I want to really make sure I hit on today, we have our annual conference coming up in Cedar Rapids, June 13th through the 15th. It's a great way to experience all things about ABI. We'll have between 500 and 600 attendees, both member and non-member companies, great speakers, educational tracks for HR, finance, legal, many more. There's so many fun networking events, just great peer sharing, best practice sharing. And one thing I'm super excited to talk about today also is we did get approval to offer member discounts to the member price to anyone on this call. So I know Amy's going to send out the link. Also, we'll include the attendee link so you all can see who else is coming, and maybe there's somebody you'd like to meet, somebody you'd like to talk to. You just reach out to me, and I will do an introduction for you, or I'm sure other people could help us with that as well. But here as a resource, and Amy, that's all I wanted to get in today with my time. But thank you.
Awesome. I can testify that this event is it's so educational. We go every year. So educational, and it's also so much fun. You guys do great events. All the networking events are a lot of fun. So I'm excited to go.
Yeah, a lot of business gets done at these events. So
yeah, you guys really do it right. Totally. Okay, we have just a few housekeeping things. So I'm going to send the recording and the slides out by the end of the day tomorrow. Everybody will get that. We have a Q&A at the end of this. I asked you guys to submit questions. I didn't think many people were going to ask questions because it's not really like a specific topic today, but I was wrong. We got so many questions. So if we don't get to your question, we have an open style Q&A webinar at the end of June that I'll be putting a link in the chat for. If we don't get to your question today, I promise we will address it in that. We just won't have time to get to all of them. But if you do have a question anytime during the presentation, stick it right in the Q&A box at the bottom of your screen, and we will get to them. Okay, I think that's it. So finally, I want to introduce our speakers. As I said, they're both joining us from Fredrikson, Olivia Norwood and Devan Rittler-Patton. Fredrikson contributes to the model policies and forms portion of our Iowa books, and we've been working with them for many, many years. So I'm so excited to have you both on. This is the first time we're ever getting like the attorney POV. So I'm really excited to have you both. Welcome.
Thank you so much. So good afternoon, everyone. Thank you so much for joining us today. My name is Devan Rittler-Patton. As Amy said, I'm a senior associate with Fredrikson and Byron's Employment and Labor Group. We are here in Iowa, but we have offices in different cities. Our main office is in Minneapolis, but Olivia and I are joining you from Iowa, as they said. My practice includes general employment litigation. So on the day-to-day, I'm litigating restrictive covenants, single plaintiff, discrimination suits. Then I also do some advice work. I edit some employee handbooks, draft some policies. And then I also have a general business litigation practice that helps inform my employment practice. I'll turn it over to Olivia briefly to introduce herself.
Thanks, Devan, and hi, everyone. My name is Olivia Norwood, and I am also a senior associate in our employment and labor group at Fredrikson and Byron. Like Devan, my practice also includes both employment advice, including advising employers on handbooks, employee contracts, and day-to-day employment issues, as well as employment litigation and some general business litigation, where I represent employers in all stages of a lawsuit, including administrative proceedings.
Awesome. So like Amy said, today's presentation will cover 10 frequently asked employment law questions that Olivia and I receive from employers on a daily basis. We'll do our best to provide our answers and discuss some practical insights and tips for best practices. Our goal is by the end of the hour, you will have learned something new, or at the very least, you will have affirmed some good practices that you may already have in place. All right. Great, I'm glad that worked. All right, so here's a little roadmap before we get started. Today we'll hit on a wide variety of topics, including hiring, including interviewing and decision-making. We'll talk about employment agreements, offer letters, and employee handbooks. Leave, including leave for new employees and leave for employees who have exhausted their leave entitlements. We'll talk a little bit about accommodations, particularly with respect to remote work, which has been a huge topic in the past few years with respect to the pandemic and post-pandemic era. Relatedly, we'll be talking about employee requests for medical information. We'll talk about some best practices for discipline and termination. We'll talk about some recent updates in the law and how we're dealing with them right now. And then finally, we'll discuss some best practices for avoiding litigation if you can. As Amy said, we'll leave some time at the end for questions, so feel free to send those through the Q&A box throughout the presentation or hold on to them to the end, and we'll cover them during that portion. All right, so let's get started. Our first question relates to hiring, and it has two parts. The first part of the question is, we search social media when we are considering a candidate for employment. Is it okay to look at a candidate's social media pages and accounts other than LinkedIn and use that information to make hiring decisions? And then part two is, what questions should we avoid asking a candidate during the interview? So somewhat related. So starting with social media. In short, there is no law that prevents you from checking social media. Social media may provide insight about a candidate's personal attributes. However, social media can also provide employers with information that is not job related that could potentially influence hiring decisions. Social media especially can reveal protected characteristics such as race, sexual orientation, gender identity, religion, and so on. And that information may not otherwise be revealed in a resume or during a job interview. So in the event that a protected characteristic is discovered during a social media search, and a candidate is eventually not hired, there is some risk that the candidate may make a discrimination claim for failure to hire. And this risk could be avoided altogether by avoiding social media during the hiring process. So all this said, we generally recommend avoiding social media in the hiring process. But if you are using it, you should think about what purpose it's serving you. What specifically job-related information are you potentially learning about the candidate? And that's the threshold. Is it job-related? So if you do use social media, if you make the choice to start viewing social media as part of the hiring process, you should do so with caution and especially with the guidance of counsel. Details like what the positions will be screened, who will conduct the actual screening, and how the search will be conducted should be well thought out and memorialized in a policy. One thing that we recommend to folks who actually do engage in social media screening is to have a separate screener who reports only those job-related results to the hiring manager, so you can help avoid those discrimination claims. So essentially, the person who is eventually making the decision with respect to a candidate is only informed as to what the job-related information was during the social media screening. So that's the first part of the question. As to the second part, anyone who participates in interviewing for your organization should be trained on the proper and improper interview questions. And this relates to some of the same topics that we were just talking about with respect to social media. Some questions that may seem like casual conversation, such as if a candidate is married, has children, how old they are, those should be avoided as they can result in the disclosure of protected class information. So questions like what church someone attends or questions about pregnancy or plans to start a family should be avoided. Other perhaps more obvious questions that should be avoided include questions about potentially a candidate's race or ethnicity. Again, those are all protected class characteristics. Another topic that often comes up relates to questions about disabilities, especially when a disability may be obvious during the interview. Interviewers should not ask a candidate about their disability, but they can ask the applicant to describe or demonstrate how he or she would perform the specific job tasks. You can also ask if the employee would need a change to the work environment or the way the job is usually done if the applicant's disability is obvious. And that's the hinge, that's the key point here. Or if the candidate has otherwise disclosed their disability and you reasonably believe an accommodation may be needed to perform the job. So again, best practice is not to ask unless it's brought up, but if it's obvious and they're hinting at it and they're talking about it, and you know that an accommodation may be needed, then you can have that discussion. But threshold issue is best not to ask. So with that, I'll turn it over to Olivia for our second question.
Thanks, Devan. Okay, so our second question is, do we need to have employment agreements with our employees, or is an offer letter enough? So employment agreements or formal employment contracts are not required, and oftentimes they are not necessary. Many employers prefer the at-will relationship with employees, meaning that either you as the employer or the employee may end the employment relationship at any time for any legal reason, with or without notice. So in order to preserve that at-will employment relationship, it's important to remember that communications with potential employees and current employees don't make any promises about the terms and conditions of employment or the duration of employment. Ideally, the offer letter and the employee handbook will include a contract disclaimer and a statement of at-will employment. It's also helpful if there's a statement in those documents explaining that only the president or the CEO or the owner or whoever makes sense for your organization is authorized to alter that at-will employment relationship. And sometimes there are good reasons to have an employment contract. So for example, if you're hiring for a higher level position, that person might want assurances of you as the employer's commitment. So you might promise employment for a period of time and include consequences such as severance payment if the employment is terminated before that period is exhausted. Oftentimes an employment agreement, though, is not necessary and an offer letter is sufficient. So the offer letter should set forth the basics of the new employment relationship. So that letter should include, for example, the start date, the place of work, the initial supervisor or manager, a brief overview of currently available benefits, whether the position is paid hourly or on a salary basis. And it also should include if the offer is contingent upon anything like a background check, a drug test, a medical exam, an agreement not to compete, or any other restrictive covenant. The offer letter should be clear that the pay, benefits, and other terms of employment are those that are currently offered, but the employer may change the terms and conditions of employment at any time, which is part of the at-will employment relationship. So even though this is not an employment contract, it still makes sense to have the employee accept the offer in writing. So include a place for the employee to sign the offer letter and return it to you. Stick that signed offer letter in the personnel file along with the applicant's job application and a job description, and you're well set up for excellent documentation of the employment relationship. I'll turn it back to Devan for question number 3.
All right. Question number 3, employee handbooks. This is our favorite. I laugh, but Olivia and I were just talking this week about how extensive reviewing employee handbooks can be, and for good reason. So we'll kind of cover some of that in this portion. So the question is, are we legally required to have employee handbooks? What needs to be in it? And how often do we need to update it? So for the first part of the question, the short answer here is no. There is no legal requirement to have an employee handbook. However, there are state and federal employment laws that you are required to follow, and a handbook is a really good and easy way to demonstrate you are complying with the relevant laws. Further, some states require that certain policies are explicitly laid out, and a handbook is a great way to do so. Additionally, employee handbooks communicate to employees what your policies are, and the policies ensure that you treat employees consistently and uniformly, which can help prevent or defend against claims of unfair treatment or discrimination. So in sum, handbooks both protect your business and provide transparency for your employees. So second part of the question, as far as handbooks contents, you should include policies that reflect your compliance with applicable employment laws. So these can include equal employment opportunity policies, discrimination and harassment policies, a reasonable accommodation policy, and a retaliation policy. If you're doing any drug testing, you should absolutely be sure to include a drug testing policy as well, or refer to it within the handbook. And just a side note here, these are extremely specific, and state laws are extremely specific as to what notice requirements should be given with respect to drug testing statutes. So just highlighting extra advice here, if you have drug testing policies, reach out to your employment lawyer to make sure that those are extensive and meeting all those requirements. Back to handbooks. Your handbook should also have a PTO policy that specifically outlines whether or not PTO is paid out at the end of employment and whether or not it can be carried over from year to year. In addition to the policies that are legally mandated that we just talked about, you should also include policies that communicate other expectations in your specific workplace. So for example, while these aren't necessarily mandated by any specific law, we recommend including written policies that lay out requirements for drug and alcohol-free workplaces, and policies that explain your expectations about social media and other electronic resources. There may also be other specific policies that are unique to your business or your industry that should be included. Another important piece of the handbook that you should be sure to include is a disclaimer at the beginning, stating that the handbook does not create a contract or alter the at-will employment relationship that Olivia was just talking about, and also that the company has a right to modify policies in the handbook without notice. So you should include a signed acknowledgement form for the employees at the end as well. Regarding that acknowledgement in particular, though, while it is helpful to have employees acknowledge they have received the handbook, remember that you have expressly disclaimed that the handbook is not a contract. So if you're withholding anything from employees' wages, such as for uniforms, a handbook acknowledgement would not be sufficient here. So essentially, handbooks advise your employees about what the policies are that can help you, if there's ever any discipline that needs to be taken, if there's a violation of a policy, even up to and including termination, but you can't use the handbook as a basis for a breach of contract claim. With respect for frequency of updates, the last part of the question, different attorneys have different takes on this. However, employment laws are changing and best practices are changing just like all the time. And this has become even more the case in the last few years with the pandemic. We are changing things all the time. We are interpreting different guidance different ways. So for that reason, our general recommendation is to review the handbook once a year at least. Once the key policies are in place, and if you keep on top of it each year, each annual review shouldn't require too much work or too much time, and some years may require little to no revisions at all. So that first initial haul may be a bear, and that's the one that Olivia and I were just joking about. Sometimes we have clients send us their draft employee handbook and say, hey, just take a quick look at this. That first initial review can often take some time because we want to make sure you're complying with everything that you need to be complying with. But thereafter, it shouldn't be too much of a haul. And on that note, one area that is particularly important to keep updated is state law supplements to your handbook. You should ensure that you have state-specific policies in place for each state where you have employees, since there may be different employment laws that apply. We'll talk about this a little bit later in more detail, but that means even if you just have one employee working in one state, you're going to want to make sure that you have state applicable handbook policies. Generally, while some approach this as having like a general handbook that covers all states where you have employees, you may end up giving employees more rights to employee benefits than they're otherwise entitled, and then may not make sense for your business. So best to have those addendums and keep those updated. With that, I will turn it over to Olivia to talk about leave.
So just to kind of add on to Devan's point about handbooks before we move on to the next question, like Devan mentioned, if it's been a few years since you've had your handbook reviewed or updated, it's likely your handbook could probably use some updates. A lot of the time when I'm reviewing a handbook for a client, I ask about their workforce, how many employees they have, what states they're in, and I learned that they have employees in states that aren't accounted for in the handbook. So a piece of advice after this webinar is maybe just to assess your workforce, look at where you have employees, including remote employees, and compare it to your handbook and make sure that all of those state supplements that Devan was talking about are in place.
Good point. Good point.
So moving on to our next question, which is about leave. It has two parts. So part one asks, do we have to give any family or medical leave to new employees? What about leave for pregnancy, childbirth, or related conditions? And then the second part is, what about when an employee has exhausted all of their leave? Do we have to give more? How much? So employees who need family or medical leave may be entitled to leave under a variety of state, federal, or local laws. So I'll start first with federal laws, since they apply regardless of what state the employee lives in. The first law that likely comes to your mind is the FMLA. Although, of course, if it's a new employee, he or she will not yet qualify for FMLA leave because they haven't been there for a year. So another federal law to consider is the ADA, which does not have that 1 year waiting period like the FMLA has. Under the ADA, a medical leave of absence may be a reasonable accommodation. So the DOL has said that there is no set leave period mandated because accommodations depend on individual circumstances. And the DOL also takes the position that leave should generally be granted unless doing so would result in an undue hardship to the employer. However, case law confirms that an indefinite leave of absence is not reasonable. So again, it will depend on the specific facts relating to the employee's leave. So just because a new employee doesn't yet qualify for leave under any applicable leave law doesn't mean that you should just automatically deny that employee's request for leave. You should also consider whether the employee is disabled under the ADA and whether a leave of absence would be a reasonable accommodation. There are also a wide variety of state and local laws that may apply and that do not necessarily require 12 months of employment. So I won't cover all of the applicable laws because that could take many hours, but I'll give some examples just to kind of get you thinking about what might apply. So for example, in Iowa, where Devan and I practice, the Iowa Civil Rights Act requires employers to provide up to 8 weeks of leave for female employees who have disabilities caused by pregnancy, miscarriage, childbirth, and recovery therefrom, but solely for the period that the employee is disabled. So even if the employee does not qualify for leave under the FMLA, she may qualify for leave under the ICRA. Other states have applicable sick leave or family and medical leave laws that also might apply. So for example, California, Colorado, Connecticut, DC, Maryland, Massachusetts, New Hampshire, New Jersey, New York, Oregon, Rhode Island, and Washington all have some form of state family and medical leave laws that may apply. So remember that even if you don't have an office in that particular state, if the employee lives and works there, they're likely entitled to the leave provided for by that state's law. So as Devan talked about earlier, this is an important reason to have those state law supplements in your employee handbooks for each state where you have employees. The second part of this question relating to employees who have exhausted their leave has a similar answer to the first part. Assuming that the employee has exhausted his or her PTO, you should consider whether there's any leave under any of your other policies in your handbook. Frequently, employers have like a personal leave policy that the employee might qualify for. If there's no leave available, again, this is when you might want to consider whether a leave of absence may be a reasonable accommodation under the ADA. We sometimes see employers wanting to jump straight to termination after all leave and PTO has been exhausted and an employee still hasn't returned to work. You just want to be sure that you're careful before doing that and first consider whether any additional leave may be required under the ADA as a reasonable accommodation. So I will turn it back to Devan for question number 5.
Great. Okay, so question number 5 is another two-part question relating to accommodations. And we're kind of doing it under the purview of remote work and some recent questions we've gotten with respect to the post-pandemic era. So part 1, I'm worried that if we accommodate one employee with remote work, more will ask for remote work accommodations. We can't let everyone work remotely. We need to have at least some employees in the office. Do we need to allow employees to work remotely? And then part 2, it's related. Some of our employees are frustrated that we are accommodating their coworkers, such as with remote work. What can we say to employees about religious or medical accommodations given to other employees? So with respect to the first half of the question, I'm sure everyone here knows that the ADA requires employers to provide reasonable accommodations to those with qualifying conditions, unless it would cause an undue hardship, and accommodations must be evaluated on a case-by-case basis. That last part is key here. This means that you should evaluate the accommodation request at the time it is made and not base your decision upon a future situation that may or may not come to fruition. So blanket policies about no remote work, that just can't happen because of this case-by-case assessment that the ADA requires. Given the change in the workplace over the past couple of years, it's become harder to show that remote work is an undue hardship. Unless the position is one where remote work is impossible, such as a receptionist or a medical job or manufacturing job. So there's very narrow circumstances. Other scenarios that may make remote work an undue hardship include situations where more work would result for someone else, or you would need to hire another employee to handle part of the employee's responsibilities. So it's always good practice to make sure that those job descriptions are current and updated such that if being in the office is an essential function of the job description reflects that requirement from the get-go. Also keep in mind that employees are not entitled to accommodations of their choice if there are other alternative accommodations that effectively can accommodate the employee. So you should engage in that interactive process required by the ADA and exchange proposals for accommodations and consider whether something else may be feasible. And some examples that have been used are private offices or more breaks. As always, you should keep careful documentation of that process, including what accommodations were offered and what the employee said. So as far as part 2, with respect to other employees being concerned about remote work being given to their coworkers, the simple answer really is that this is confidential employee information that other employees aren't entitled to. Communicating that can be difficult, so I have the kind of scripted response that may be helpful. So here's a way of saying that. Thank you for your concern about your coworkers' remote work. You are correct that our general company policy requires employees to be in the office. I am sure you know that there are some special situations where the company may choose to or is even legally required to deviate from its policies due to an employee's family, medical, religious, other needs. Obviously, you understand that specifics of those situations are confidential personnel matters. The company cannot share another employee's confidential personnel information with you. And likewise, we would not share your confidential personnel information with other employees. So that's just one example of how you can kind of confront that conversation. Important to iterate that that's confidential, but also that you would treat their information confidentially as well, as I'm sure that they would hope you would. So this also means, though, that HR, ownership, management, and supervisors all need to abide by this confidentiality and make sure that everyone is accountable for maintaining that confidentiality regarding employee accommodations. So with that, I'll turn it over to Olivia for the next one.
Thanks, Devan. Okay, so we're going to stay on the remote topic for remote work topic for one more question. So question number 6 is one that we're seeing more and more frequently, particularly in the last few years. Question 6 is, our organization allows employees to work remotely, and some employees have moved to different states. Is this okay? What are the implications? So an area that is sometimes overlooked when employees move to other states is the impact of that state's employment laws on your organization. Many states have employment laws that give certain rights to employees who work in that state, even if you don't have an office there. So for example, while Iowa doesn't require employers to provide any sort of paid sick leave or other paid family leave, like we talked about earlier, many other states do. So if you have an employee who has moved to California, for example, they're entitled to the paid family and sick leave provided for in that state. Other states also may have different requirements for minimum wage and overtime, different meal and break time requirements, and leave laws can vary significantly from state to state. So if you have employees living in states other than the state where your offices are located, like we've mentioned several times already today, your employee handbook should include state supplements with state-specific policies for each state where you have at least one employee, even if it's just a remote employee. So this is an area where we frequently see employers needing their handbooks to be updated, since oftentimes employers don't realize that their handbook needs to account for the locations of their remote employees as well. Another implication that you should consider are the tax consequences of having employees in other states. I am not a tax lawyer, and the specifics of those are beyond the scope of this presentation, but just wanted to flag that you may have tax obligations in the states where your employees are working, and you should confirm that you are withholding payroll taxes in the proper state if you have employees living and working remotely in different states. Additionally, you should consider what changes might be needed to your workers' compensation insurance. So, while it's certainly permissible to allow remote employees to live and move to other states, you just want to be sure that you're complying with the relevant laws in the states that they live and work in. And sometimes we hear about employers later learning that a remote employee has moved somewhere else, which can kind of create a sticky situation. So one way to get ahead of that is to have a policy that requires employees to notify the company in advance of any remote, any work location changes. I will turn it back to Devan for question number 7.
Remote work makes everything easier and somehow everything a little bit harder too.
Right.
but worth it. All right, question 7 is medical information. So kind of in the theme of the post-pandemic era and some questions that we've gotten. So question 7 is, when can I ask for medical information or a doctor's note from an employee? And what should I do with medical documentation when I receive it? So to start out, there are a few easier scenarios that you're already likely familiar with respect to when you can ask for medical information. First, if an employee has requested FMLA leave, the FMLA itself permits employers to require employees to obtain a completed certification from the worker's healthcare provider to substantiate the need for the FMLA leave. A subsequent request for a doctor's note is generally considered a request for recertification, which is only permitted every 6 months or under very certain circumstances. Further, if the employee is returning from FMLA leave, a fitness for duty request is permitted. So that's number 1. Second, if an employee has asked for an accommodation due to a disability, so something we've talked about thus far, the ADA allows employers to request information from a doctor to find out more about the employee's impairment and determine whether it rises to the level of an ADA disability when the disability or need for accommodation is not apparent. So number 1, FMLA, number 2, ADA. And third, when an employee has been out due to a work-related injury, so for workers' comp, it's generally permissible to require a doctor's note or release to return to work. So those are the 3 more obvious circumstances where the answer is kind of easy to answer. A trickier scenario arises when an employee is calling in sick or has a health-related absence, but has not specifically requested FMLA leave or an accommodation. So if you have a sick leave or attendance policy that requires a doctor's note, it's generally permissible to ask for one. So going back to one of our first slides, that employee handbook, great place to put in a policy about asking for this type of medical information because it's generally permissible. Having said that, the scope of what you can ask for is limited. The required note should not seek a diagnosis or medical condition. Rather, the note should verify that the employee was seen by the healthcare provider and stipulate any period of incapacity or job-related restrictions. So again, we're seeing some recurrent themes that job-relatedness is super important to narrow the scope of the information provided. You don't want to get too much information, just enough to help you make the business decisions you need to make. Another tricky scenario comes up when an employee is returning from a health-related absence and you have reasonable belief that the employee presents a direct threat to the health and safety of other individuals at work. So this has come up quite a bit with respect to the pandemic and viral illnesses that you're afraid of maybe an employee being contagious. In this scenario, we'd recommended talking to an employment lawyer, getting counsel, just because it can get really sticky. You may be able to request a note from the employee's doctor stating that the employee is not contagious, or to identify any workplace modifications that may need to be needed to protect the health and safety of others. However, such an inquiry could technically violate the ADA, again, if you're unable to demonstrate certain criteria such as, yet again, job relatedness, and that the medical inquiry is consistent with a business necessity. So even in situations where the illness is not a disability under the ADA, privacy and discrimination laws restrict an employer's ability to make medical inquiries that are not job related. So in sum, there are 3 easy scenarios where you are able to ask for this information. The trickier scenarios, it may be permitted, but you need to be very careful about the scope of information you're requesting and obtaining. Second part of the question. As for storage of an employee's health information or medical records, we sometimes see that these are put into personnel files. Really easy to do. But technically, health and medical documentation should be stored separately in a secured medical file that is separate from other personnel information, and medical information should, of course, be kept confidential. This information in the medical file cabinet could include FMLA paperwork, notes from jobs, notes from doctors, job restrictions from a physician, and workers' compensation reports and requests for accommodation under the ADA. And just a note here, in preparing this presentation, and Olivia and I talked, we've had so many folks not know that things should be kept separate. In fact, when we first started practicing, I don't think that we would have known that these types of documents need to be kept separately. On the back end, when we're defending these claims in litigation, how this often comes to fruition is we'll ask the employer for, let's say, the employee and issues personnel file, and we'll get all of this medical information, and it'll just be kept in the same file. That's not best practice. You need to be keeping them in separate locations. Anything else you want to add to that, Olivia? I know you and I had talked about this.
Yeah, we were just talking about this yesterday. It's really so often we're in the midst of litigation, and we ask a client for personnel files for the employees at issue. And a lot of the times, FMLA documents, other medical information is just lumped into the personnel file. And those documents really do belong in a separate, secure, confidential medical file like Devan was talking about.
Yeah. All right, moving on. Number 8.
Okay, discipline and termination, everybody's favorite topics. So question number 8 is, what are common issues you see when it comes to discipline and termination? What are the best practices for disciplining and terminating employees? So oftentimes when a case comes to us as employment lawyers, we start to investigate the background facts, and we learn that the paper trail and the documentation just isn't as clear as we wish it would be. We often wish that the client would have come to us when the performance issues were occurring or when the termination decision was made, so that we could help ensure good practices are followed and good documentation is in place if you ever need to defend that decision down the road. So I'm going to share some tips that will hopefully help you avoid that scenario and best set yourself up for a strong defense. So sometimes we see employers with strict progressive discipline policies that require something like a verbal warning, then a written warning, then termination. So while progressive discipline oftentimes makes sense, you want to be sure that your discipline policy allows flexibility to respond to each situation as it arises. In some cases, it is appropriate to go straight to termination. You don't want to later face a claim related to the fact that you didn't follow your own policy by failing to follow the progressive discipline that is mandated. Your policy should clearly allow you to accelerate discipline when necessary. In general, when an incident arises that might require employee discipline, the best response is to document that incident, explain its impact on the business or customers, explain what change is expected going forward, and document what will happen if those expectations are not met. So this will help set clear expectations so that the employee can't later claim that they didn't know what was expected of them, or they weren't told what the implications of their conduct would be. With respect to terminating employees, here are a few tips. First, ensure that you're following your written and unwritten policies and practices. This is a common issue we see where even if an employee deserved to be terminated, an employer didn't follow its own policies, which can give the employee some fuel for a pretext argument if they later make a discrimination claim. You should also consider whether you're treating the situation the same as you have others in the past. So even if this isn't like a written policy, but just your general employment practices, if you're treating this employee differently, be sure that you can justify why the employee is being treated differently and go ahead and document that reason. As always, document the incident, your reasoning, and anything that happens during the termination meeting. It's a good practice during terminations to have one person present who's there to talk and another person who's present and there to take notes. If there are any unusual risks, such as the employee recently made a complaint of discrimination or recently returned from a medical leave, it's probably a good idea to consult with counsel so that you can avoid claims of retaliation or best be able to defend against them if they were to arise. And depending on the situation, you should also consider whether a separation agreement and a release is appropriate. Finally, when you are terminating an employee, it's important to explain any expectations upon termination. So that would include any post-employment restrictions or company property that needs to be returned. Okay, I will turn it over to Devan for question number 9.
Awesome. All right, so question number 9 is a little bit different. It concerns some legal updates that have emerged this year. While each of these alone, full disclaimer, could constitute their own webinar, we thought we'd be remiss if we didn't acknowledge them here, as they are coming up quite frequently in client conversations. So because these are still new, their impact is also not yet known. So our goal here will be to inform you of their existence and suggest some good practices for dealing with them until we have more dispositive guidance. So first part of the question, should we make any changes to our employment documents given the NLRB's new guidance on confidentiality and non-disparagement language? So first things first, let's discuss the legal update. Earlier this year, the NLRB issued a decision in a case called McLaren-McComb, in which it held that severance agreements containing overly broad non-disparagement and confidentiality clauses violate employees' rights under Section 7 of the NLRA, which is a provision that protects employees' rights to unionize and join together to advance employee interests. So Section 7 is not a new thing. I'm sure a lot of you are already aware of it, but this holding in this decision and then subsequent guidance is new. In March, the NLRB General Counsel, so their lawyer, issued a memorandum providing guidance on the decision. Essentially, it's guidance from one lawyer to a bunch of us other lawyers who are trying to understand its impact. It covered a number of things, which we don't have time to cover here, but in particular, the memo indicates that the NLRB's stance on those confidentiality and non-disparagement provisions could apply outside of just severance agreements, but also apply to other employment documents like employment agreements, separation agreements, and offer letters. So moving forward, the NLRB may be more critical of broad confidentiality and non-disparagement provisions, or just them entirely, in those types of documents. And the concern here is potentially limiting employee speech with respect to their terms of employment and their rights under Section 7, that they can join together and talk about these issues. So that's the legal update. What are the key takeaways for you right now? First, it's important to remember what this is and that it's just guidance. It is not dispositive law. Having said that, it does reflect how the NLRB intends to prosecute these types of provisions moving forward. And it does show a lean against these types of provisions in the employment setting. Second, it's important to consider whether the NLRA even applies to certain employees. Specifically, the NLRA applies only to employees that are not classified as supervisors. Often this analysis hinges on whether the employee is exempt or not exempt, but there are some nuances and some exceptions. And for that reason, we recommend getting counsel from an employment lawyer to ensure that you're making a comprehensive assessment of the risks should you be interested in keeping these types of provisions in your employment documents. The main thing is to keep this guidance in consideration when you're reviewing employment documents generally. Again, while it's not currently law, it could become law. And so to ensure you're prepared, you need to take a look at your relevant provisions and employment documents. So all of the ones we've talked about, not just severance agreements, and ensure that they are narrowly tailored. Also give some thought to including disclosures that the employer is not seeking to infringe on Section 7 rights. Just full disclaimer, that may not be enough. Some of the parts of the NLRB memo on this, the general counsel's memo, is that a disclaimer like that may not be sufficient, but it certainly can't hurt you, especially during this kind of wishy-washy time where we're trying to understand the impact of this guidance. So seek counsel from an employment lawyer if you're considering keeping these types of things in your employment documents, but just know that this is guidance for now. Part 2 is somewhat similar, just a different topic. It concerns, should we make any changes to our restrictive covenant agreements given the FTC's proposed ban on non-competition agreements? So you may have heard about this in the news. Let's first discuss what this legal update is. In January, the FTC issued a proposed rule banning non-competition agreements entirely, with some exceptions, very few exceptions. But since then, it has started accepting comments from the public to take into consideration before making it law in some shape or form. And this started as a 60-day period of notice and comment. They've since extended it. So clearly a lot of employers, employees, the general public have thoughts about this proposed ban on non-competes, and they're hopefully taking them all into consideration. Here's the key takeaways. First, like I said, just like the NLRB guidance, it's important to remember that this is not law yet. That said, it's worth noting that a number of states are starting to implement their own bans to restrictive covenants while this has been pending. So just as an example, I think I mentioned Olivia and I practice at a firm with our headquarters in Minnesota. Just this past week in Minnesota, they have proposed and passed a bill. It's waiting to be signed right now with their governor, but it's otherwise passed, prohibiting non-competes, and it's becoming about the 4th state to do so. So this shows a broader trend against non-competition agreements, and even in some cases, non-solicitation agreements. So what should you do? Every situation is going to be different. We recommend taking a look at your agreements and giving some thought to whether they can be edited or these provisions could be omitted entirely. We're encouraging employers to give some thought to the goals they're wishing to achieve by having the restrictive covenants in place. In some situations, those needs could be filled by a general non-solicitation or even just a confidentiality clause. In others, they can be served by narrowing the scope of a non-competition agreement geographically, temporally, or more substantively. And again, those will still come with risk just because we don't know if there will be an overall ban or if your states will have overall bans. So just good to take a look at those documents, see what efforts you're trying to serve and how they could maybe be pulled back a little bit to serve those best interests. Again, for both of these updates, it's important to remember that changes, if any, that you make are a business decision and informed by your business's comfort with the risk. So it may be to your business's benefit to buck this guidance and do whatever is best for you, knowing that there are risks in play. For others, the risk may just be too severe and you want to abide by it just in full safety. For that reason, it's best to speak with an employment lawyer while reviewing your documents so you're taking all those risks into consideration. That was a mouthful. I'll turn it back over to Olivia for the last question.
Thanks, Devan. Okay, so our last question is just kind of a final catch-all. What is your best advice to avoid litigation or to win in the event of a claim? So something you probably hear from employment attorneys, and you've likely heard us say throughout the presentation today, is the importance of good documentation. Having good documentation helps both in explaining things along the way and avoiding any misunderstandings, as well as refreshing memories that may fade over time. So for example, if you're defending a charge of discrimination 6 months after an incident, you might not remember every specific detail. Documentation also is very helpful in defending charges and in showing that the reason for your actions was not discrimination or retaliation. And in that respect, performance evaluations are often important documentation where we frequently wish that more care and attention was spent. If at all possible, human resources personnel should review at least a sample of each supervisor's evaluations of his or her employees and discuss those evaluations with the supervisor. We all hate bad news and we don't want to be confrontational, but truly it's better to have no evaluation at all than to have an evaluation of a poor performer that just doesn't reflect that reality. We see it over and over again where a plaintiff claims that they were discharged due to some illegal reason. The supervisor says that it was because of performance, but the evaluations say that the employee was satisfactory, and the employee claims that they never had any performance issues. So being open and upfront with employees about performance concerns when they exist, rather than hiding them with satisfactory reviews, is another way to avoid that surprise element if an employee is later terminated, which sometimes can fuel those discrimination charges. If evaluations are being performed, they should be done correctly. And if you can get your supervisors to manage and document performance on a continuing and ongoing basis, regardless of the evaluation schedule, that's even better. Employees should be treated with respect and given notice of their performance issues when they exist, and if appropriate, an opportunity to fix them. Another tip to avoid litigation is to follow your policies and past practices and treat employees consistently. So we oftentimes see claims arise when an employee perceives that they are treated different than others, or when they are surprised by their termination. If you have followed your policies and practices and have performance reviews and other documentation that show performance concerns, an employee is less likely to be surprised by a termination or believe that they've been treated differently. And one final piece of advice, and really the best way to avoid litigation altogether, is to get a release from an employee. If you're giving an employee any sort of separation pay or benefit that they are not otherwise entitled to, you should receive a release in exchange. So we sometimes see employers trying to be generous by forgiving tuition repayment or paying out PTO when they don't normally do so, or some other type of separation benefit. If you're doing this, you really should require the employee to sign a release, even if you don't anticipate at the time that employee might later bring a claim against you in the future. So thank you so much for your attention this afternoon. It looks like we have about 8 minutes left for Q&A. I know that Amy mentioned we've already received some questions in advance that I think Amy is going to moderate. So feel free to submit more if you have any, and we will get to them as we have time. Otherwise, as Amy mentioned, I think there's an upcoming webinar where this is addressed.
Yes. Thank you both so much. That was packed full of great information. And it doesn't matter which law firm we're working with or what attorneys I'm working with. Every single one says, please document, like better documentation. Even if you think you're doing a good job already, you can document more. So
I'm sure you guys get sick of hearing it from us, but it really is so important.
But it's so important. Yes. Okay. We have a couple of questions. Somebody's asking me to show the credit codes again. I put the credit codes in the chat. So you all can access them there. Like I said earlier too, I'll be sending out a recording of this and some slides of these slides. And I'll put the credit codes in those emails as well. If you can't take these down, you'll get them tomorrow. Okay, so we have some good questions here. Just stop me if you've already answered them. I was trying to pay good attention, but just stop me if one
Sure.
is a duplicate.
Yeah.
So the first one is, how can we obtain additional information in regards to a medical restriction or accommodation request to address vague info?
Sure. So I'll take this one because this kind of picks up on one of my slides, which is requests for medical information. So to the extent I'm not answering the question, I'll try to get to like different variations of this in case it's not the question I already covered. But to rehash, generally the ADA permits an employer to request information from a doctor to find out about an employee's impairment. So that's something we talked about earlier for purposes of determining whether that type of medical condition rises to the level of an ADA disability. Again, the inquiry must be business related. You can ask from the employee. So that's a way about going about it. You ask for this type of information from the employee to get it from the doctor. For a work restriction, like in a workers' comp situation, it's generally permissible to request that the employee provide a doctor's note or release to return to work. So again, you're going to the employee for that. And then another variation of that, I think you were saying, like, if it's vague information, the initial information you get back is vague. A way to go about getting more information after an unclear initial request is to speak with the employee and kind of explain why you think that this information is insufficient for you to get the information that you need. Ask specific job-related questions about how the impairment affects the job performance, and that can help you kind of facilitate going back. If they need to go back to the doctor to get more information, you can just go about it that way. But again, the key here is to maintain questioning that's job-specific and job-related, so you're not going outside the scope of it.
Perfect. Okay. This is an interesting one. I've never heard this question. Can an employer legally limit an employee's bathroom usage without a doctor's note?
Yeah, that's a really good question. This is one actually that's like come up with Olivia and I. We were talking about it earlier with respect to different leaves. Big picture, this is actually state specific. I think it just in like different questions that have come in, some states require that a certain amount of time is permitted per every few hours. For instance, I think I saw that like California, and again, I don't practice in California, but I think I saw once when I was doing some research that they permit, I think they require that you give like 10 minutes per every 4 hours or something like that. So first things first, this may be state specific. You should probably consult state specific laws. Generally speaking, it's not the best practice to try to limit this type of break for various reasons. OSHA has provided guidance that you're not supposed to be unreasonable on your limitations about an employee's request to use the bathroom. Obviously, I completely understand if there's like a rogue employee who maybe there's reasons why you want to try to limit this type of thing. But generally speaking, it's best to not limit it if you can, just because there may be circumstances where like, you know, maybe an employee is expecting and has to use the facilities more frequently. Maybe you'd find out information about that employee that again would be not job related necessarily, but would impact, you know, an actual interactive process for a request for accommodation. So there's so many things that you could be tipping the iceberg, just the tip of the iceberg, and getting that information. So best not to limit if you can. But again, I acknowledge that there are some scenarios where maybe this could be taken advantage of. And in those scenarios, I would recommend consulting with counsel, just so you can kind of weigh the risks and go about different ways about getting that information in that specific scenario. It's probably going to be fact and employee specific. Anything else you'd add to that, Olivia?
No, I think that's good advice.
Awesome. Okay. Are companies federally required to give salaried employees unlimited partial time off under 4 hours?
Yeah, I can take this one. This is a good question. So the short answer to this is no, but it's a little more complex. So as you likely know, the FLSA requires exempt employees to be paid a fixed weekly salary, and that can't be reduced based on the number of hours worked. So pay can only be deducted from an exempt employee's wages if they're absent for a full day. If an exempt employee works for just part of the day, they must be paid for the full day. So it's important to remember that exempt employees shouldn't be micromanaged, and they're paid really to complete the job tasks, not to work a specific number of hours. Sorry, our lights are automatic, and so they should every so often. Just to continue here, you know, the more that an employer nitpicks at partial time off, they begin treating an exempt employee more like an hourly employee. So, however, with respect to PTO in particular, for partial days of absence, employers are allowed to require exempt employees to use PTO for partial day absences. That half day increment used to be commonly advised, but in recent years, there has been some case law that confirms it's okay for employers to draft PTO policies that require exempt employees to use PTO in less than 4 hour increments. You just want to make sure that those expectations and requirements are clearly set out in whatever policy that you draft. One caveat here is that you should make sure your policy complies with any applicable state leave or family and medical leave laws, because sometimes those will have restrictions on PTO increments. Also remember that if an exempt employee has used up all of their PTO, but they need 2 hours off for a dentist appointment or something like that, you can't then deduct pay for that partial day of absence.
Yeah.
They have to work 0 hours for that day.
Right. Yep, exactly.
Okay. We have two questions that just came in the Q&A box that are like almost the same exact question. So I want to address it. You discussed employees living in another state. What about employees in another state temporarily, like a couple of weeks? Same concerns? And just to add on to that, let's specify that the person doesn't reside in that state and there's no office in that state.
Yeah, so this is a question we sometimes get, and honestly, the answer is not super clear. So if an employee, sometimes a remote employee might, work for a month in Florida in the winter or something like that. And employers sometimes ask, okay, well, how long does an employee have to be there for those employment laws to apply? It's going to be state specific. In some states, their employment laws will say something like, okay, if an employee has worked in the state for 4 weeks, then they're entitled to these benefits. But a lot of times, state employment laws do not have any sort of like minimum period that an employee has to be working there. So 1 day working in that state might be enough to trigger it. So if you have remote employees working in other states for some extended period of time, you probably want to look at the state employment laws in that state and see if they apply to that situation.
Oh, that's complicated.
That is, and it got another good reason for them to check in, right? Because often you don't know what's happening. That happened a lot during the pandemic. People just go like, get a house in Utah.
Right.
Yeah, and the employer sometimes wouldn't even know,
Yeah, exactly. And that's why we say it's a good idea to have a policy that requires your employees to, advise you in advance of any work location changes.
That's a wonderful idea. Yeah, that's great. Okay, well, we are at 1 o'clock. Thank you both so much. This has been such a great presentation. I really appreciate both of your times. And thank you so much for everybody for joining us. We've got 2 webinars coming up in June that I put the links in the chat. And yeah, again, I will be sending out those emails tomorrow. I hope everybody has a great day. Thank you.
Thank you.
Bye-bye.